Okay, everyone, welcome back to lecture 2. We basically are continuing our coverage of the concepts of defects in mutual assent. And we basically are going to be talking about specific types of defects in mutual assent and mutual assent. We additionally are also going to be talking about consideration as contract requirement, and finally we're going to talk about the writing requirement, which sets of contracts are needed to be in writing. Now, first, we want to start talking about threats in mutual assent. Uh, um, One thing that we know is negotiations are the process. Negotiation process is one where we present facts uh, about the agreement that we're going to be entering in, and it's a process where we actually do this factual representation, and we basically have we can actually do mistakes, or we basically can basically have misrepresentations happen in the process of negotiation. And the question is, does contract is based on misrepresentation of facts for any reason, whether it's fraud or misrepresentation, the contract really hold or not? And the idea is that you have to answer questions, whether there's deceit or not. Like a misrepresentation could be due to that someone is acting fraudulently, or it could be because someone just made a mistake, or and they were unable to represent the facts clearly to the other party. So if there was actually deceit on behalf of one party, there are multiple types of three main types of remedies that could be invoked here, or things could be awarded to the deceased party. First, the deceased party may actually ask to just cancel the transaction. That would be one thing. They can just ask that they don't want to perform their transaction. The party also may actually push over if they basically had made any expenditures in reliance. They basically relied on the promises that were made, or the presentations that were made, and as a result of that, they spent some money, and they lost some money in the process. Additionally, one thing that's new is basically that they can also claim, or actually, the courts can award for punitive damages, and those punitive damages are damages that basically have the intention to punish the party that that had this fraudulent conduct. And what we mean by punishing them, it basically is not awarding an amount that's commensurate to the damage that happened. It's actually awarding more. And it's more of kind of a slap on the wrist. So we'll talk about punitive damages and the difference between them, and other types of damages, or the other types of awards during the course of the semester. But for now, one thing that you need to remember is that punitive damages are awarded by courts just to punish someone for an act of negligence, or actually act of fraud that they commit. So continuing on, basically, uh, the one case where you have fraudulent misrepresentation is the one we discussed. However, there could be cases that there is no fraud in the process. So basically, it's the misrepresentation is made with no intention to deceive the other party. So we can actually have two types of misrepresentation that are not really deceitful. One is basically based on just an innocent mistake, and the other one could be just based on negligence. Both of those are obviously less morally reprehensible than fraud, and therefore they command, or so courts in general would award fewer remedies to the parties that have been deceived in this case. So in the case of just a negligent misrepresentation, the victim will probably recover damages that are due to them based on compensate the losses that they incurred as a result of the cancellation, or they basically can just ask for the cancellation of the transaction. However, in the case of innocent misrepresentation, the only likely relief is the cancellation of the agreement itself. Um, if parties do want to cancel an agreement because facts were misrepresented to them, or facts were not disclosed. Actually, this is the third thing, which is non-disclosure. So we talked about fraud, misrepresentation, and non-disclosure. In earlier cases in the past, courts would place the responsibility on both parties to disclose information that's not known to the others. However, more modern courts right now, there's an increasing tendency to place the duty to disclose only when the matter is of importance and it is not likely that the other party would be aware of it during the time that they are forming the contract. Another method or another reason why contract mutual assent could be effective is what we call economic duress. And just to understand the meaning of duress, I have to ask you this question: if someone asks you to sign a contract at gunpoint, would that contract be valid? And the answer is obviously not, because you do not have a free will to negotiate, and you do not have the free will to say no to that contract. So the idea here is that physical duress is no longer the thing that, I mean, as society evolved and we basically advanced to a point where not many people would put a gun to you to actually sign a contract. Now we actually have evolved that into the concept of economic duress. So, just as a reminder, a valid contract does require freely given consent, and in early common law cases, duress was of physical type. So basically, had a more violent society that would basically put people under physical intimidation in order for them to enter into context, possibly. But more days, more modern times is basically economic. So more modern duress is principally of the economic type, or sometimes what we call business compulsion, where you actually have a large company that will force smaller companies or smaller entities that deal with them to enter into certain types of contract with them, and they basically don't have any way of negotiating their terms. And if they don't sell to those people, they basically lose their, for example, livelihood. So basically, it's one of those situations where you have business compelled to interact in a certain way with a certain business. It basically exists if one party does exert excessive pressure beyond what's considered to be permissible bargaining, and economic duress is one of the things that have been found very rarely in very few cases, and the reason for the hesitance is that it basically there are pressures inherent in the bargaining process, and it doesn't want to, and of course, not want to limit the ability of people to bargain contracts. So it basically was found in very few cases, and it was not a common phenomenon to find them in the courts. The third effect that could basically impact mutual assessment process is what we call mistake, and it's basically the doctrine that most affects the contract. So basically it's most used to attack contract formation. So we use it the most, or people use it the most, to say that no contract even exists because of this mistake. So we do not see eye to eye, we do not have offer and acceptance. It's not a mutual assent process is effective as a result of our inability to understand each other, or there was a mistake in the contract itself. So there are three types of mistakes that we can see. First is a mistake in the terms of the contract, or a mistake that will be caused by fraud, or a mistake in an agreement that will basically make it not reflect an earlier understanding. So we agree on something, but something happens in the writing that basically does not reflect our earlier understanding. So, for example, you understand that you're going to be buying this car today, and discover that in the contract it says that you buy it in 3 months, but you understand that you want to buy it today. So that could be one other type of mistake, or a mistake in the basic assumptions based on which the contract is made. So, for example, you assume that, for example, foreign currency is widely available in a certain country, and that's a mistaken assumption. You basically go there, and the contract is in foreign currency that you cannot find. So it's a mistake that you basically make the assumption that certain things were possible. It was an obvious mistake as a result of your ignorance and lack of knowledge of this particular setting. So some very few generalizations could be made about this doctrine of mistake. The one is the fact that if you have careless behavior from one side, one party, that party becomes less likely to be given any relief. So, for example, the example I just gave you right now, if someone entered in contract with with a foreign policy, a foreign currency, and they were did not investigate, it was proven that they did not investigate enough to know whether the currency is available or not. That's basically could be proven to be careless, and it basically warrants them less relief than someone who did the due diligence and were unable to discover this mistake. The argument of a mistake by a party is probably more likely if there is a situation where we have someone is getting something for nothing. So, for example, if we make a mistake in the value of a contract and we forget a couple of zeros. So, let's say, for example, you're buying a house for $2,000 that's worth $200,000. So basically, someone is getting a house for near nothing, for $2,000, which is 1/100 of what the house is costing, and therefore basically is unfair. So it's an unfair situation. So that argument of a mistake is more proven easier in that way. Um, so basically, if we continue on our generalizations, if one thing that's also a common generalization, there aren't that many, is that if a mistake is discovered early, before reliance takes place, before someone acts in reliance, that is, it is more likely that just would be not enforced, would be just cancelled, and the transaction would be cancelled, and no one would have been would lose anything. There are three main policies that govern court decisions in that regard. First, that the parties should be basically released from certain undue risks. So basically, there are risks that you are um, not expecting, and they're undue to you, and basically you should be relieved from those. So that's a policy that the court would uphold. The parties basically should not be allowed to avoid performance by dishonest claims of a mistake. So basically, if you are if you're trying to get out of a contract by just saying it was a mistake, so the court should basically usually would try to see through that and make sure that you're not just trying to avoid performance by this dishonest claim, and therefore in such a case, they would basically enforce some form of a contract. Parties should be able to rely on agreements, so you basically should be able to. So this policy says that basically we can't allow for everyone just to come and say we see a mistake in the contract and we have to get out of it, because now no one can rely on an agreement. The agreement will not be worth the paper it's written on. So therefore there has to be some sanctity given to that contract and that writing, and it should not be allowed easy for people to claim mistakes and try to get out of their obligations. Um, Courts usually scrutinize three following main factors. There are four main factors. First is the relative degree of negligence. So if there's negligence on both parts. Is one party more negligent than the other? And if that's the case, then they're probably more likely to be held responsible for the mistake. Is there a party that knowingly assumed a risk that they knew? So basically any assumption of risk, knowing the assumption of risk that they know of. Any disparity in exchange values. So remember, for example, the value of a house that's $200,000. If someone is said to be selling it for $2,000, so that's kind of an obvious mistake there, that someone is selling a house for 100th of its value. And the likelihood that we can return the status quo or restore the status quo. So if the transaction was we basically had this contract, and we were in a certain situation, both parties were at a certain situation before this contract came into place. Is there any likelihood? Is it possible for us to return things? Like a court can basically return things to what they were before this contract was issued. And in general, if this restoration of the status quo before the contract is possible, it usually warrants the cancellation of the contract. So it makes it easier for the contract to get cancelled. Another defect to mutual assent is the defect that we call unconscionability, and we mentioned that before. So unconscionable conditions are basically conditions that shock the conscience of the judge. So for example, the traditional example from English literature is a contract for where someone is going to be giving a pound of flesh in case they default on a contract, on a loan contract. So if they're unable to loan, they will basically pay it back in a pound of flesh. So this is an example but that's by the way from Shakespeare's Merchant of Venice. The idea here is that this is shocking to the conscience of the judge because it's really unfair. It's an extremely unfair conditions, and in many cases, courts refuse to enforce contracts that are unconscionable. It started actually really in something called the Uniform Commercial Code, the UCC, in Section 2302, the Sales of Goods, which basically gave judges the power to strike out all or part of a unconscionable contract. So basically, they can say the entire contract is unconscionable, or that this specific aspect or term of the contract is unconscionable, and therefore they would strike it out. Um, Gradually, this concept is become accepted for all forms of contract, not just the contracts for the sales of goods. And courts could find unconscionability contracts, especially in contracts that have been imposed by a stronger party, a more dominant party, to a weaker party that's less capable of bargaining and negotiating. Um, so clauses that can be struck down as unconscionable tend to be in most court decisions that are available. First of all, they tend to be related to customer transactions rather than commercial transactions. Obviously, because the customers are the weaker party in this regard, commercial transactions are usually between equivalent or equal sized or even like at least large enough entities that are capable of defending themselves. They tend to also be ones that included sharp dealings in bargaining rather than harsh terms. So the terms themselves may not give enough justification for striking out articles or terms as unconscionable. The harshness of terms is not enough cause. However, the way it was bargained is sometimes enough cause for showing unconscionability, where basically one party is unwilling to show any flexibility. There is obvious evidence that one party is unable to change any of those, and so on and so forth. They also tend to be ones that exculpate obligations or make the vindication of the other party's right very difficult. So let's say, for example, you're a French company and you're dealing with a company in Australia, and you say that you basically in order for you to sue me, you have to go all the way to France and sue me. Or if you're an American company and you basically are working in a country, for example, in the Middle East, and for example, you're required to, for example, make contracts in a language that you're incapable of understanding, or so on and so forth. So this makes the vindication of your rights very difficult. Or the other type or the other reason, which is the exculpation of obligations, is that you write in a contract that, for example, I'm not responsible for this, while it's really one of your real responsibilities. So you're trying to get out of a responsibility or an obligation in the contract, although it really, in custom practice, it's really one of your obligations. So you're trying to, for example, you're an owner and you're saying that I have no obligation or I have no responsibility if the plot of land that I'm using for building this project has, for example, toxic waste. It really is an obligation of yours to make sure that this land is clear and free for obstruction for the contractor to work, and if it happens to have waste on it, toxic waste on it, basically it's your responsibility to clear it. So if you exculpate yourself, that may be found to be unconscionable by court. So this is an example of an exculpation from an obligation there. The, this doctrine of unconscionability has not made any direct impact on design and construction contracts. The exception is basically for the exception is really the fact that it does create a responsibility on owners to verify bids that appear to be mistaken to avoid unconscionability. So, for example, if you receive a bid that is for building a $10 million facility and you know it is exactly $10 million, and you find that the bid, one of your lowest bids, is for $1 million, this appears to be a mistake. So I mean, in the past, if you don't want, if responsibility does not apply, you can just take that bid and basically just drive the contractor into ruin because they basically have made a mistake. They would of course argue that they made a mistake and they'll try to say that there's defective mutual consent. However, even if that was not found to be a mistake, or for example the mistake was not able to be proven or was due to carelessness or whatever, still there's an argument of unconscionability because it's really unfair to have a contractor lose that much money. So that's an example of that. The development of the doctrine, however, so this concept of unconscionability has been developing in more decisions and more legal thought, and it allowed and encouraged courts to examine all circumstances and intervene more frequently in contracts that they feel be unfair. So they would look at the situation, they would look at past dealings of the two contractors or the two entities with each other. They would see the current situation in the market. So, for example, if it's a situation where we have very little work and then people are forced to go work for very low rates or for very harsh conditions, these conditions may actually play in, and the court may strike some terms of contract that are very tough, more frequently as unconscionable. Um, Now, the final thing we want to talk about about mutual assent is something called formation defects and restitution. And here we want to define a concept of something that's called restitution. It's basically conferring benefits when claims cannot be based on a valid contract. So, okay, I grant you that we do not have a contract. So this is what is the saying is that let's assume that we do not have a contract here. Are there benefits that need to be conferred on party, not based on a valid contract? So there are two main cases for restitution. The first case is that if we have no one with whom a valid contract can be made, and there are examples of that. So for example, the classic example in your reading is you have a physician, a medical doctor who's walking by, and someone is stricken and by a falling object, and they basically help resuscitate them and make sure that or help basically take care of them in first, using first aid and so on and so forth. The question is, would that physician be entitled to any compensation for their action? And the answer is yes, because although there is no contract, the person was probably stricken unconscious by the whatever falling object that was. The physician is still entitled to basically compensation under restitution. So basically, they can receive some benefits as for the actions that they perform. A more close example in construction. So let's say, for example, in a disaster situation, let's say a flood, the contractor finds that there is a levee of some sort that will be breached, and they go ahead and they basically fill up some sandbags, or they just take their excavators and they just try to raise the area and make sure that the water doesn't flood the area where they are. And the question would be: was there a party with whom they can make a contract or contract with? There is no party, but they actually could be entitled for compensation under um, restitution. Another case is the case where basically the parties intended to make the contract but did not do so. So basically we have a situation where we really wanted to enter into contract. Some party may have startup performance, or they acted in reliance, made most of startup performance, and they're asking basically whether they recover on the performance they made, and answers that yeah, sometimes they can recover on the performance they made before the contract has been fully construed, and that will be done under the doctrine of restitution. In construction, there are two main formation defects that prevail. First is if we have no little certainty or lack of certainty in the terms, parties do not agree on the terms and work with progress. Parties did intend to formalize a contract, but they did not, and there is a misunderstanding of a contract term. So these are three conditions that could happen. So that would lead to lack of certainty there. So basically, uh, we start work without having a full agreement on terms. Parties intend to formalize the contract but not necessarily the terms. In this case, the parties did still believe that they have or would have a valid contract, so this is a clear distinction. Another situation in construction that would create a formation defect is basically if contracts are made illegally. So mostly it happens in public contracts and that require competitive bidding, so there could be two types of mistakes. One mistake would be basically if there was, for example, an illegal act of bribery, for example, if someone, a public official would award a contract after receiving a bribe, and the other one would be if there is an honest mistake made in the technicalities of how a public contract should be done. So, for example, the bidding process was not performed exactly according to regulations or rules or whatever. Um, in the case of the restitution, the amount of benefits given to the parties that are requesting to receive a compensation, they can actually range between two things. They can actually range from the value of the expenditures to the value of the benefit conferred. What's the difference between the two? Value of expenditure meaning that this is how much money that they spend, and this is what they want back. The value of the benefit conferred may actually include also the benefit, the actual profit and overhead that they would charge regularly on this type of work, and they would basically have would receive that as well. In some very rare cases, the recovery will be made for expenditures that did not benefit the other party. So, for example, you go buy materials and you spend money on buying those materials, it did not benefit the other party, but still you got those materials and no one would know what to do with them since this contract is not going to go through, and so in this case you can actually cover expenditures that do not benefit the other party. Um, so in the second type of in the second type of formation defects, it's basically the trend is usually to grant recovery to parties who performed in good faith. So we usually find that contracts that are made invalid due to technical irregularities, but not by illegal conduct. So if there is a technical irregularity in the bidding process, that may grant or allow for restitution or for benefits to be paid in restitution. However, if there is illegal conduct, this would deny recovery by restitution. Okay, so the second topic of our discussion today is something called consideration as a contract requirement, or the functions of consideration, or basically one of the sub topics that we want to talk about is the function of consideration. And the first question I have for you is: are all promises enforceable by law? So, for example, if you make a promise to your younger brother or sister that you're gonna hand them down your iPhone, your current iPhone, but for whatever reason you have, you basically decided that you're gonna go ahead on eBay and sell it and use the money towards something. Is this promise an enforceable promise by law? And the answer is that not necessarily. Not all promises are really enforceable. Some promises are not really important and are not intended to create an enforceable obligation. So, the example of this promise to your younger brother or sister, and the promise maybe by a parent to take their kids to the zoo on a weekend. These are not really really enforceable promises, and they do not create enforceable right. However, some parties could be forced to And the reason that we actually say that not all promises are enforceable is that some parties could be forced to promise things without receiving anything in return. And the question again, would that be an enforceable promise? The answer is no. So if you promise, for example, that you're going to take someone to the zoo and you're not getting anything in return, if you're going to give someone an iPhone, give it as a gift, and you're not receiving anything in return. So the distinction between enforceable and non-enforceable promises is really the fact whether we are getting something in return or not, and that's what we call consideration. So the thing that you get in return for your promise is what we call consideration, and consideration is actually the main doctrine that's used to determine which promises are enforceable and which ones in earlier law, in early law, basically earlier decisions, the law would require that there would be a benefit to the promisor in return for the promise. So there will be a need for some exchange of benefits, or that the promisor will receive some benefit, whether it's monetary or otherwise, in return for the promise that they made. Later decisions actually started to see that whether the promises would basically allow for promises to be enforced where the promiser did not receive any pecuniary or monetary benefit. And the question I have, why would such promises be enforced? So, if, for example, you're promising someone something and you're not receiving anything in return, you're not receiving at least any money in return. Why would such a promise be enforced? And the answer is, if the promisee did suffer some detriment as a result. For example, you make a promise to a charitable organization that you're going to give them some money, and as a result they go ahead and start building a building, and they basically incur that money, and you basically you come back and say, you know what, I'm not getting anything in return, so I'm going to go back on my promise. But you can't at that point, because the promisee did suffer because they acted in reliance. Um, if we basically if the promisee did suffer any form of harm or any form of loss as a result of the promise that you made them, then that would be grounds for granting them some benefits. Um, so early in the past century, the concept of bargaining started to evolve. Of course, at that point, did not just stop at looking at the exchange of the benefits. They basically no longer look at the benefit or detriment to a certain party, but they look at whether there's some form of a bargain in the transaction. And if such a bargain does exist, then there is consideration. They find that consideration does exist in the case of the existence of a bargain. So, for example, one good example is that, for example, if you make a promise, like sureties now, if you go into the bidding process, many sureties would actually offer you the bid bond that you present as part of your bidding documents for free, with the expectation that once you're awarded the contract, you basically go for them and get the performance bond, and that performance bond will be something they will charge you money for. So, can someone say that the bid bond is not really an enforceable contract in this case because the surety does not receive any money? The answer is, according to the bargain concept, that does not exist because the bargain does exist. They're basically providing you the bid bond because it's part of a bargain where you actually are going to confer to them some benefits probably in the future for a different contract. So that's the concept of bargain there. Um, a bargain does not really necessarily have to be fair, except in certain consumer transactions, and again, that's a form of protection that's afforded to consumers as a result of fact that recognition of the fact that they are probably the weaker party in the transaction. Um, so moving on, so we talked about the fact that if reliance exists, then that makes the enforcement of a promise important. And this common code I'm going to show you here is a code from something called the Restatement of Contracts, which basically is a major document, major legal document that kind of summarized all decisions related to contract law in the United States. And this is the second restatement, and this is section 90, paragraph 1, and it states a promise which the promiser should reasonably expect to use an action or forbearance on part of the promisee or third party, and which does induce such an action or forbearance, is binding if injustice can be avoided only by the enforcement of the promise. So what does this say? It says that if we have a promise in which the promiser, the person who's making the promise, knows that there is going to be some action in return for this promise, and this action actually did happen by person who's promised, or whoever third party exists, and basically if injustice, if there's the only way for us to make things right for the person, the promisee who basically acted in reliance, is the enforcement of the promise, then this particular promise would be in this case enforceable. The doctrine was originally developed to enforce promises. So that, for example, the example I just gave you, in which a charity was made with promise of a certain amount of money, and they went ahead and started plans for construction. They started construction, so they started incurring some cost for the building. The person who says that who made the promise that decides to back up, they can't, because the charitable organization in this case acted in reliance, and they started getting the construction going, and they started incurring some cost for that. It's actually now used for transaction, and it basically is used to supplement the bargain concept. So it basically is used to look at along with the fact that whether bargain exists or not, and whether reliance exists or not, and whether one party is entitled for the full or partial enforcement of the promise. Reliance can extend to the following commercial areas actually. So basically it can extend into promises, for example, promises of bonuses to employees, and the type of reliance that this creates is the reliance is basically an employee staying in a job in order for them to get the bonus. So you can't say that I give you the bonus for nothing, for it's good. There is no consideration that exists for the employer giving a bonus, so it's not really enforceable. However, if it can be proven that the employee acted in reliance and stayed in the job in order to get the bonus, then that basically can become an enforceable promise. A promise of manufacturers to a franchise dealer. So, for example, if a manufacturer says that you know what, we're going to increase the number of cars that you can sell, and that resulted in the investment of money and expansions. So if there's an investment and expansions that have been made, this is an act of reliance, and therefore the promise by the manufacturer to the franchise dealer is promised and enforceable. For example, bids by subcontractors to prime contractors. So, for example, if we have a subcontractor that was promised a job, and they acted in reliance, they started, for example, hiring people, buying materials or whatever, and then once the contract is awarded to the prime contractor, the contractor went with someone else, they basically can claim that they acted in reliance, and they can claim the damages that the promise of them being selected for the job can be enforced, or at least they will be compensated for the losses that they've incurred as a result of acting in reliance. Um, so basically, past consideration is the final thing that we want to talk about here. So the question is, can we actually have a contract that's based on something that you received in the past? So, for example, you'd have a contract and say that I'm going to build you a house in return for the $100,000 that I got from you a year ago. Is that something possible? The answer is that usually promises motivated by benefits received in the past are not really enforceable. However, there are exceptions to that. In some states, promises that are based on past consideration are enforceable in a few cases, and that is to the extent necessary to prevent justice. So, if this promise that's based on past consideration is needed, enforceable enforcement of, or is needed for preventing an injustice, then you basically have to enforce it. And also promises to pay discharge debt. So, for example, if you were in debt to someone and you basically had that debt being discharged from you by way of bankruptcy or whatever, and you decide to go back to that debtor and say, you know what, I'm going to do this in return for the amount of money that I owed you in the past that was discharged. So this is a form of past consideration that is basically that basically could be used for that case. So as I mentioned, that could have been discharged by bankruptcy or statute of limitations, and in this case you can go back and say, you know what, I'm going to do this work for you in return for the money that I owed you in the past that was discharged by either bankruptcy or by statute of limitations. So what do you mean by statute of limitations, by the way? A statute of limitations is the fact that certain transactions are only valid for a certain amount of years. These are called the statutes of limitations. So the enforcement of those promises or obligations ends by a certain period of time, and if a debt is basically discharged as a result of a statute of limitations taking place, then you basically can use it. In some states, it can be used as a form of past consideration. Okay, now moving on to the next topic, which is basically which promises are enforceable still. The enforceability of which comes from the format in which they are written or the format in which they are presented. So one format of a promise that has been historically one of the most enforceable types of promises is the promises that of something that's called a promise under seal. Um, uh, it was really prominent in times where people were unable to write, so people were unable to formalize writings a lot, and they basically not have the ability to sign also. So they would usually carry a seal, which is basically just a ring that's a signet ring, and they basically had it's an instrument that they basically can create an impression on soft wax or on ink, for example, or using ink. They can use that to create an impression on a document, on a piece of paper, basically. And it usually was used for emphasizing the seriousness of the transaction, uh, and it was actually enforceable to the point that even consideration was no longer necessary. So in the past, a promise under seal is one that didn't even require consideration because it's that serious that you would use your seal to make a promise. U.S. seals were basically reduced to basically just writing the word seal or the abbreviations LS at the end of the document, and which basically led to its eventual loss of power. Many states now actually deny the seal any function, so they would look at the circumstances of the promise and whether consideration exists and whether a bargain exists. They will not give the seal any weight more. In some states, however, documents under seal still have some enforceability, still create presumption of consideration since they uphold it as still something very important. So moving on, so the question is that are all contracts, do all contracts need to be in writing? And if so, which ones require to be written in order for them to be enforceable? This is actually something that came to the attention of British legislators in the year 1677, which is over 300 years now ago now. And the English Parliament at the time passed something called the Statute of Frauds, and it's actually a law. It's one of the oldest still applicable laws that requires a sufficient something called a sufficient memorandum to be signed before judicial enforcement. So basically, it required that you'd have something uh, sufficient, sufficiently representative of the transaction or the agreement on the transaction before any judicial enforcement of that specific transaction would be allowed. So you can go to court and claim that there was a promise or there was a transaction that needed to take place unless you have a sufficient memorandum that represents this transaction to the judge. And the reason that it was required is twofold. First, it's to protect the litigants from dishonest claims, and also it was also created to protect courts from hearing claims of questionable merit. So basically, you don't want people on the street just saying that this person promised me so and so, and I acted in reliance and I lost that money. So you don't want to have this crowd of courts, and you also don't want to have innocent people attacked by that all the time. Therefore, there was a requirement. This law created a requirement of writing or creation of a sufficient memorandum to represent an agreement in certain cases. Uh, it basically acts as a warning device, cautioning people that they are taking a serious obligation. So it basically tells people that, yeah, be careful. This is something that's really serious. You're entering into a real obligation. So by signing this document, so basically it creates that warning. And the statute of frauds is really adopted in almost all U.S. Jurisdictions to different extents, of course. Um, the things that required to be at least defined in the statute at the time, the original statute required the following transactions to be in writing. First is, for example, a promise by an executor or administrator to pay damages of their estate. So, for example, if you have an estate belongs to someone who's deceased and there's an executor or administrator of this estate, then any promises to pay damages by their estate would basically be required to be in writing. The promise to answer for the debt or default of miscarriage carried by others. So let's say, for example, you are going to be a co-signer for someone's loan and that person defaults. You basically, in order for this agreement to co-sign or become a guarantor of someone who's in debt, in order for you to do that, it has to be in writing in order for it to be enforceable. Agreements on consideration of marriage, which is really interesting, that people have to, in order for those to go to court and be enforceable, they basically have to be in writing. Contracts for the sale of land or interest in land, so anything that has to be to do with the sale or interest in land has to be in writing. Agreements made on contracts that are not going to be performed within the year. So if you're basically making a contract for something that you're going to do after a year in more than 1 year, you basically have to have it in writing. Contracts for the sales of goods over specified values is also going to be required to be in writing. So these were the things in in the uh, in the original statute. There are other examples from more modern times than right now. For example, some states require real estate brokerage services to be a contract in writing. Contracts to leave property by will. So if you decide to leave a house to someone in your will, it needs to be in writing. Home improvement contract, you have a contractor that will come in and do some work on your house, that also needs to have a written contract. Uh, California also, that's kind of an example also of the writing requirement. California requires the contracts in writing to be signed by both parties and to be retained for at least 1 year by a buyer and a seller of a single family dwelling. So if you're living in a single family house in California, you should at least hold your written document for at least 1 year. Um, uh, Sometimes the classification of transactions may limit the effectiveness of a statute or a fraud. So let's look at this example. So if you're if you're a contract for building a 20-story house, which is a significant building, or 20-story building, which is a significant building that costs millions of dollars, that contract may not be required to be in writing because the court could conclude that it basically is something that you perform within the year. So it's not going to take more than a year to perform the work, and therefore it may not have a requirement to be in writing. It does not require to be the contract does not need to be actually in writing. The second question we have is, so what is a sufficient memorandum? The sufficiency of the memorandum is basically something that came under question even more recently with the rise of email and electronic communications. So a memorandum in general has to be signed by the parties. So in order for it to be valid, it has to be signed by the parties. And the question is, how could an electronic document be dealt with in this case? If you have an email or something that we're exchanging, or a PDF document that we're exchanging, how can we deal with the electronic signatures thing? And the answer is that Congress has enacted a law that's called the Electronic Records and Signatures and Global and National Commerce Act, and that basically is a law that provided for a method to validate signatures on electronic communications and allowed for the use of digital signatures and on electronic documents and electronic exchanges. Unfortunately, now the use of those digital signatures is very simple and inexpensive. Um, uh, in general, if you go back to just any form of memorandum that would be used to prove existence of an agreement, in order for it to be considered a sufficient memorandum, it must contain the basic terms, and it does not need to express the entire agreement, but it has to have some of the basic terms or terms. It does not need to be signed at the time of the agreement, the time the agreement was made. And basically, the Uniform Commercial Code, the UCC Section 2-21, paragraph 30 says that the writing requirement can actually be satisfied by admission during litigation for goods or for transactions. So basically, if you're in a transaction and you go ahead and admit that you in court or if you're in the litigation or that there is an agreement, that may actually suffice as a written suffice or would basically be sufficient for creating a sufficient memorandum. Following question is that can the writing requirement be avoided? The answer is probably yes. Sometimes oral agreements that are required to be in writing are enforced, and for example, the UCC states that the acceptance of part payment is sufficient to make an oral contract enforceable. In cases of the sale of land, contracts could be actually enforceable by part performance, and basically that could be substituted for writing. So, for example, if a buyer takes possession of a piece of land, they start making improvements, that they basically would at that point would have an enforceable promise or enforceable contract. However, part payment is not sufficient. So if they pay part of the money and they don't have a written agreement, that's not sufficient to have performance happen. But if they're allowed to take possession of the land and make improvements to it, that's actually more evidence of the contract itself. So that may actually create a waiver or substitute for the writing requirement. And in service contracts, so for example, if you're a contractor or if you're basically a lawyer, you have a service contract. Full performance in this case would actually bar the application of the statute of frauds. However, this does not apply for home improvement contracts, which become part of the statute of frauds, and they require to be basically they are required. Some jurisdictions also would actually enforce oral contracts if reliance is created due to a promise due to a promised written agreement, or if a party is unjustly enriched. So, if a party basically gets someone else's work, or they will get the products or goods, and they will go back and claim that they have no agreement. This is unjust enrichment. They got something for nothing, and therefore, in that case, and also in the case of reliance, sometimes an oral agreement would be enforced. Um, in many states, however, the statute has eroded over time, and courts would be willing to listen to a claim if it's genuine, if the claimant has relied reasonably on the oral agreement. Sometimes they also would be allowed to prove the agreement by actions rather than by a written document. But in general, this serves kind of as a warning for people to really consider having a written document in most cases, if not all cases, if that is also possible. Okay, everyone. So thank you very much for this for listening in to this second lecture. I'll be posting this also as well. One thing that I want to say is that I actually kind of expect you to kindly watch those two videos. So I probably should have said that at the beginning, but I really expect you to watch those before Monday, so we can actually go ahead and build on this starting next Monday. See you, class, and looking forward to getting to know all of you. Thank you.